for joining. My name is Mitch Kraus, Chief Operating Officer here at Goodwin and Company, and very pleased to introduce Connie Heyer with the law firm of Niemann Heyer. I'll let you introduce yourself to the masses.
Hello, I'm Connie Heyer. I probably know some of you. Thanks so much for being here. I'm a lawyer that specializes in HOA representation, and Goodwin and I share mutual clients, and I don't represent Goodwin or management companies, but I work a lot with Goodwin and their great managers. And I'm really pleased to be with you today and get our hands around what happened this legislative session that's going to affect your association, your management company's action items, your legal action items. And it was a busy session. And I do a lot of volunteer work for HOA advocacy and member advocacy. And Goodwin provides a lot of support for that. People going to the Capitol, testifying, talking to representatives. It's definitely a team effort. And we had a pretty good session, or a pretty not bad session, which is about the best that you can hope for in HOA land. And so we will go over today what passed and how that's going to affect day-to-day actions or needed actions from your association or lawyer or manager. And then also what didn't pass, near misses, what we can expect next session to come back for more, and just the themes of what the legislature is trying to do to HOAs, which I think is helpful to hear. And, forewarned is forearmed, because we're going to see it again.
Yeah, I always love Connie is so intimately involved in the legislative process. It's always also fun as part of these recaps to just talk about the near misses, or the things that we just need to be have a heightened sense of awareness on as the next legislative session approaches, because there's a good chance that it might might be something that we confront again in the future. So awesome. So we'll go ahead and get started. And just a couple housekeeping notes. So I've got everybody muted. You do have access to the chat function. So if you have any questions, please feel free to type them into the chat, and we're going to do our best throughout the session to get to those questions. And then we'll save some time at the end for some Q&A. Sound good?
Great.
All right. So we'll go ahead and move that over. All right.
So the legislative session is over. Many of you probably know the Texas legislature meets every other year in odd numbered years from January through May. And so the legislative session has concluded. They're calling some special sessions that don't really affect HOAs. The only thing preventing everything from being final is the veto deadline that Governor Abbott has, which is a couple of days from now. We don't expect anything that we're talking about today to be affected by a veto, but we just wanted to outline the timeline for y'all.
Cool.
So some laws that pass apply to condominiums, some apply only to homeowners associations, and some apply to both. And the only difference, it doesn't matter if you have shared walls, it doesn't matter if you own the dirt. Literally the only difference in a condominium and an HOA is that condominiums have shared ownership of the common elements. You own your unit plus a 1/100th undivided interest in the common elements. Whereas in an HOA, there's nothing in common owned by the owners. The HOA owns any park or pool or anything like that. And that's just by definition under the statute. And that sometimes causes confusions, because townhomes with shared walls are often HOAs instead of condos. So it is important to know. If you don't know, your manager will certainly know. You can ask your Goodwin manager, but if you don't know whether you're a condo or an HOA, that's something that would be helpful to know.
Yep, very good.
So we think of ourselves as this niche industry, but legislators get a lot of calls, usually greatly exaggerated, as someone who is on the other end of calls from legislative offices saying, can you help this constituent? But they get a lot of calls from constituents. Oh, my HOA is so mean. They sent me a letter because my trash can was out for a week. And that puts HOAs in the spotlight quite a bit. So this session, we had more than 150 bills filed that directly would have affected property owners associations. And as we'll talk about, only 3 of them passed. And some of them were somewhat tangential, but still would have affected day-to-day operations. So when I first started doing this about 25 years ago, there may have been 3 or 4 bills filed related to homeowners associations. So that tells you the exponential growth, the exponential, oversight that the legislature is imposing on HOAs, meaning, and it's good and bad, a lot of it is good, but it makes it much more complicated to administer HOAs. It makes you even more reliant on your management professionals and HOA attorneys, because self-managed is almost a thing of the past, which is a little bit sad, especially for the smaller associations who feasibly could self-manage, but it's just almost gotten impossible because of the complications the legislature continues to impose.
Yeah, no doubt about that.
So there was after the last legislative session, the House of Representatives appointed what they call an interim committee with an interim assignment of what needs fixing in HOA law, which is always a little bit scary because what needs fixing is different in every stakeholder's eyes. But I work with a volunteer organization called Texas Community Association Advocates. And we are a stakeholder, and we were invited to a stakeholder roundtable with the Texas Association of Realtors, or Texas Realtors. And we talked about what, in our opinions, need fixing. And there was a bill last session that some of you may remember, Senate Bill 1588, that was really, really sweeping and said anybody can build any security measure on their house that they want to, and HOAs can't do anything about it. Well, people were taking that very literally and saying, okay, I get to enclose my front yard, even though there's a sidewalk that my neighborhood kids ride down. They're really annoying kids. So I'm just going to enclose that sidewalk in my front yard and call it a security measure, and enclose that drainage easement. And now the drainage swale is going to get backed up by the fence and flood. And so we brought that to the legislature stakeholders' attention and said, this shouldn't happen. Sidewalks shouldn't be blocked off. Drainage easements shouldn't be blocked off. These are safety things. And you would not believe what a task it was to get that fixed. And the people that were against it's odd and bizarre. But at the end of the day, as you'll see, we did get that fixed. Another real pain point, probably more for Goodwin, because they're the ones that had to pick up the pieces, is there was a law that passed last session that said that board members could not serve on the Architectural Control Committee. Well, as probably you, everybody on this call is probably the usual suspects, as I call them. The same handful of people end up volunteering for everything because you're go-getters, you're doers. And even in the really large associations, we found that often you didn't have enough volunteers that were not board members to fill the architectural committee roles. And what a lot of associations were having to do is pay architects to serve on the architectural committee, or pay someone to serve on the architectural committee. And that's not good for anyone. So we brought that to this stakeholder meeting and got that addressed. And we'll talk more about how that's addressed going forward. And then the realtors wanted to impose some additional restrictions on condominiums and kind of bring them parallel with HOA law, which didn't love it, but it's kind of hard to argue with the law being consistent for HOAs and condos. So we'll go into that, but I did sit down in a stakeholder meeting and talk through some things, which was really helpful, and ended up getting a bill passed that we'll talk about a little further on. Yeah, we talked about this a little bit. So the Texas Association of Realtors, which is now Texas Realtors, was the real driver behind Senate Bill 1588 last session. And the realtors, one of their concerns, which concerned us greatly, was they wanted to curtail rental restrictions. A lot of associations have had headaches with short-term rentals and want to curtail, for example, short-term rentals. And we did see some attempts to do that this session, which were not successful. So we just continue to be on guard for anything that would affect HOAs. And our goal as my lobby organization, my volunteer organization, is not to dictate policy, but is to allow associations to self-manage, and not self-manage, but decide the rules under which they want to live on by their owner votes, and not have the legislature dictate a one-size-fits-all policy. Like we're going to talk about chicken bills in a little bit. There was the inevitable chicken bills, but there was a bill that the legislature wanted to pass that would have required HOAs to allow each and every owner to have at least 6 chickens. Well, what if your lot is a quarter acre or 4 acres? That's a really different consideration, and owners should be able, our feel is owners should be able to decide that on their own by owner vote, rather than having the legislature dictate it. And the same for rental rules. I mean, I'm not here to say that everybody should prohibit rentals or short-term rentals, but every community should be able to decide on their own and not have the legislature dictate it, is our position at least.
Mhm.
Okay, so here's the first bill that passed. So this is the cleanup bill that I was talking about from the stakeholder meeting. And at the end of the day, what it said was, even if it's a safety measure, somebody comes to you and says, I need a perimeter fence for a safety measure, you can prohibit front yard fencing if your documents prohibit front yard fencing. The only exception is if somebody is exempt from public disclosure of their address, like under the appraisal district records, like judges and public figures for safety reasons are exempt from public disclosure, or if you have a law enforcement certification that you're under, heightened risk of security, like maybe you have a stalker or something like that, then for those legitimate and documented reasons, the HOA has to make an exception for front yard fencing. But in general, one of the action items is if your documents don't disallow front yard fencing and you don't want to have to allow it, you should adopt a rule to disallow front yard fencing, with those exceptions. And then the new law specifically says that if there's a drainage easement, which often, especially in like Leander and the Rolling Hills, Bastrop, there's drainage easements in a lot of front yards, drainage swales, you do not have to allow front yard fencing in those areas. And then with regard to condominiums, this is to bring condominiums parallel with current HOA law that passed last session. If you have more than 60 units in your condominium community, you have to have before September 1st, a website with all your governing documents on it. And that can be a private portal. Goodwin has a great portal that a lot of its clients use, and that is access to the website. So luckily, I think that, Mitch's folks can get condominiums clients up to speed very quickly.
Already there. Yeah.
That's great, because that's going to be a big task for a lot of condominiums that don't have the infrastructure of that kind of support. But it's a good thing. You should be able, and it should make the board members' lives and Goodwin's lives easier when people can go and answer their own questions by quick reference to their governing documents. So that's a requirement.
So one kind of takeaway from this is for POAs need language adopted if the docs don't currently prohibit front yard fencing. In your estimation, how many communities would this apply to?
Oh gosh, I would think most. I represent several hundred. I've only probably remember maybe 10% have, no front fencing in front of the front building line. But it is something that I do suggest you have your HOA lawyer review if you're interested, because you want to nip that in the bud and just be proactive. And you got a couple of months. You got until September 1st to have something of record. So yeah, I would do that audit as soon as you could.
And specifically, that doesn't apply to condos. So when we're talking about front yard fencing, how does that apply? And have those security measures been taken a step further pertain to condominiums?
So theoretically, they apply to condominiums, but they only apply to land owned and controlled by the applicant. And typically that doesn't include condominiums. I mean, maybe you have a condominium that's more like a single family home that it would apply to, but that would be unusual.
Townhome type communities.
Right. Okay, so last session, there were extensive new management certificate requirements. A management certificate is something that is filed of record, basically to point the title companies to your manager at Goodwin, so the title companies can request a resale certificate if someone is selling a home. And so the management certificates in HOAs last session had to be, every one of our HOAs had to file a new management certificate with a lot more detailed information. And now that law has been mirrored in condo law. So before September 1st, we're going to be busy refiling management certificates, because now they have to list every single transfer fee, every single, not just a declaration, but every single amendment. And then the standard things like how to contact Goodwin, what your association's website is, the new condo website. So that's going to take some logistics, and we're already on it. I've been emailing, Goodwin's person in charge of that, and it's just something to get done. It's not particularly complicated, but it has to be done, because if you don't get it done, what the law says is you can't charge for attorney's fees for collections if you don't have this management certificate in place by September 1st. And then the resale certificate cap, resale certificates are what by law these HOAs have to give owners who are selling their unit, and the same applies for condos. And they say things like, what are the regular assessments? What are the current reserves? Are there any special assessments currently due and unpaid? Are there any violations known for this lot or condo? And that's a lot of work. And it's not just pressing a button and regurgitating, a memo. It is individualized to each association, and not just each association, each lot or condo. And that's a ton of work, but the legislature assumes that people just press a button and make, a money machine. And so they've capped resale certificates at $375, which I think is not American, but it also means that, everybody has to make money, and you have to recoup whatever you're losing on resale certificates, somewhere else. So, that's Goodwin's business. But what I think clients can expect is fees might have to slightly raise somewhere else, because you can't lose money doing something that's part of your job, doing resale certificates. I wish the legislature would just let market forces control, but this is something that realtors it's really the realtors that are behind it. They don't want any fees. They don't want any fees at closing, except for theirs, of course. And so they want to, limit closing fees to make their transactions easier. So that's really the impetus behind this.
And one thing to note, and this is something that happened with the last legislative session, TREC set up a website for those management certificates. It used to be you'd file it with the county, and now you're also filing it with their website, and they've created a fairly easy to use website that allows us to upload those certificates, and keep manage those and also very easily searchable. So something to check out. If you're interested, you can Google TREC management certificate search and see all of that relevant information. I got one other question for you in terms of the condo management certificates. You said that is going to include, is it basically everything that has been filed for that association that has been recorded for the association,
It's
or
just the the plats, the
declaration?
condominium plats, which is in condo land, it's usually the declaration that is the plat, but it is the declaration and declaration amendments. It doesn't have to be bylaws and rules,
Okay.
but it's the declaration and all declaration amendments. And just kind of something for y'all's radar, because Mitch was talking about the duplicative filing requirements with TREC. What is pretty clear is that the realtor's ultimate end game is to have some kind of ombudsman, and maybe TREC serves as the ombudsman and mediates disputes of HOAs with their owners, which it sounds like maybe a good idea. The problem is, if you're making it really easy for owners to cause their association to engage in mediation, you're paying me to be there 20 times a year. Your budget is going to have to greatly increase, and it's just a little bit of a roll of the dice. That is something that we're concerned about. We think we do a good job self-policing. Like, I get calls from legislature all the time, and Mitch gets calls from owners all the time that think they're being mistreated. And once you know the facts, you can work through it, unless there's nothing you can do for them because they're just not being reasonable.
Yeah.
It is pretty easy to work through it. So I think our industry is very good with self-policing, and I'm hoping we can stay that way.
Yeah, it's a noble concept. It's having some kind of a regulatory body that can help mediate issues is a novel idea, but the reality is that it takes quite the force.
Mhm.
Having lived and worked in other states that had some of those processes in place, it became very difficult. Certainly backlogs very quickly.
Well, and volunteer board members, I think it would chill or eliminate volunteerism, because you're going to get drug into
Yeah.
a hearing 20 times a year,
Yeah.
however many times people file mediation complaints.
Yeah.
It has some challenges.
Yeah. There's a question that came through. Does the resale cap apply to all HOAs, BOAs, condos? And the answer at this point now is yes. So, and that's something that we modified 2 years ago when the initial passed, and did that, sweeping across the board. So if you're a Goodwin client on the call, it's already been taken care of.
So also with this new fix-it legislation, we input into the statute flexibility for board members to serve on the Architectural Control Committee. So how we addressed it was, if your HOA has more than 40 lots, you send candidate solicitations for the Architectural Control Committee, just like HOAs send candidate solicitations for board members right now. So your management professional is used to that. They do it in their sleep. They know the drill, and it's the exact same protocol. So you'll send Architectural Committee candidate solicitations. Whoever responds by the deadline, great. But if not enough people to fill the Architectural Committee role, slots respond, then the board members can be considered to fill those vacant positions. So I think it's a good compromise. Yeah. You go to the well that is not a board member first, yeah, but it allows you flexibility to have board volunteers as well.
Yeah, I agree. I think it's a great idea. I think it's I mean, that's what we faced when the initial, rule passed that board members couldn't serve. It just became very difficult, and board members had to choose, where am I more valued in the community? Given architectural requests are pretty important to have some background on and work through. We had a lot of folks who were great board members who had to jump off the board to serve on the ACC. And I always found that to be unfair in a world where it was very difficult to find folks to volunteer. So I think this is really nice. And I know Connie will work with us and help build out a nice template for candidate solicitation process, but very similar to how we handle board solicitations, and certainly give everyone a fair shot at joining. And if they don't, then we are good to go with having someone on the board serve. It's a good happy medium there.
So next we're going into another bill. You'll see the usual suspects typically file kind of anti-HOA bills, Representative Shaheen, but to his credit, he's listening to a constituent, he's filing a bill, and he's trusting legislative counsel, they call it, the drafters for the legislature, to kind of make what he wants, his vision, happen. And he was really nice about working with us about practical problems to the as filed bill. So as the bill was initially filed, every homeowners association, in order to find, and this doesn't apply to condos, every HOA would have had to file a new rule of record that listed each category of violation for which you could impose a fine. And that is like, how long is a piece of string? Okay, fireworks, aggressive dog, parking violations. I don't know how we would ever do that. And so when we talked to him, he was very receptive, his office. And so the way it ultimately passed was HOAs, in order to fine, and this is effective January 1st of next year. So you're going to have to adopt a new rule that lists each general category of covenants for which you can assess a fine. Well, that's pretty straightforward because everybody knows the category of covenants: bylaws, declaration, rules, architectural policies. That is approachable and doable. And so you have to include a schedule of fines for each category. And what we also were successful in convincing the representative of the need for is, we need the ability to depart from that schedule, because all fines aren't created equally. Someone shoots a gun off in the common area, that's a lot different fine than someone leaves their trash can out. And so, but it's also great to have a schedule of fines, because that leads to consistency. That makes it easy for the board and your manager to say, what should this fine be? Okay, this is nothing out of the ordinary, that we're going to impose the standard schedule. And then only are you taking board time and management time discussing the outliers that that warrant a departure from your standard schedule. So I think at the end of the day, this is good. Some associations probably that aren't professionally managed, or their management companies not on top of it, are going to be caught, a little bit on their heels, because maybe they're going to assess fines without this policy in place as of the 1st. But just know that this needs to get done by the 1st. And Goodwin can certainly help you get in touch with your HOA attorney. It's not going to be particularly hard, but it just has to get done.
Yep. Awesome.
So this was another pretty very concerning as filed bill, but as ultimately passed, it's not going to affect your day-to-day operations a whole lot. So this was a bill that would have greatly lengthened the collection process. And HOAs have to have cash flow. You have to have cash flow to maintain your pool, to maintain your parks, whatever exterior improvements you're in charge of maintaining. And if you're not bringing in that cash, the rest of the owners are footing the bill for the difference. And that's not fair because you have to raise assessments. And so this, as filed, would have added 3 certified mail notices over 90 days to the already very intricate collection process. Before anything can come to my office, Goodwin sends an already required certified letter that gives owners 45 days to pay and gives owners, outlines their right to a payment plan. So that way owners have a chance to settle things before the attorney ever gets involved and they incur those fees. And so that's already of record and required. So this would have added 90 days to that process. Plus you couldn't have filed a lien for another 180 days. So you were looking at an additional 9 months plus the already 45 days in current law. So you're looking at not being able to take meaningful collection action for almost a year. And that would have caused people to understand that they could get away with not paying for quite a long time, and really started creating bottlenecks, because it tends to snowball. When people figure out they can get away with not paying, then more people figure it out and more people figure it out. So this would have led to assessment increases, collection costs, and cash flow issues. So we can go to the next slide. So as it was finally passed, we compromised on 2 notices, which is in effect 1 new notice, because there already is the notice that we've talked about, the Goodwin already sends. So the first notice is a regular mail or email notice. Courtesy notice, hello, you're late. No particular form, just hello, you're late. And then 30 days later, you send your second notice, certified mail, but that can be the notice that the Goodwin already sends for you, that 45-day notice. And so really, some people will have a change of protocol if you haven't already been sending courtesy notices, which I think most people already do. And so really the only change is you'll have to make sure that after that courtesy notice, you wait at least 30 days to send that second certified mail notice. But I do think this was a good compromise. I think it's fair to kind of mandate courtesy notices before they get charged for a certified letter. So I think we're thankful that we were able to work through it, because the as filed would have been really hard for and detrimental to associations.
Yeah. And again, this pertains specifically to HOAs, not condos.
Not condos, that's right. So this passed with regard to income discrimination. This is not going to affect your day-to-day existence as an HOA, but some associations prohibited rentals to, for example, Section 8 tenants, like tenants that were, they prevented their owners from accepting Section 8 housing vouchers, for example, lower income housing vouchers. And the legislature didn't like that. And so basically you can't, if someone is authorized to rent in your community, you can't disallow certain types of payment. But you can still have other rental rules. A lot of associations have short-term rental restrictions, for example, but you just can't discriminate on the basis of payment. You can't prohibit landlords from taking certain payment. And I've never seen this an issue in any association I've ever represented, but I think in maybe Dallas or Houston, there were some associations that had this on their books, and we didn't have any problem with this legislation.
Very rare.
And this won't affect your day-to-day life either, but it does relate to HOAs. And some really, really old subdivisions have really old restrictions that expire after 50 years or expire after 100 years. And then it's a free-for-all. And so the clock is ticking. And I'm sure this is probably filed for one association or one community in general. That's how this legislation typically happens. So if you've got a super old subdivision plat that's more than pre-1947, your owners can get together and extend those restrictions. But that's just not really something that's applicable to most.
What does that process look like? I mean, if there's any.
Oh, it's a petition. It's a 66.6, I think, % vote of those owners. And it's similar to other chapters of the property code that allow certain, unincorporated associations to do the same thing, or deed restrictions without associations. The owners can petition to extend. But yeah, it's basically a super majority vote of the owners. And the builders came back again and took more pounds of flesh with curtailing construction defect claims. This is a big deal for condominiums. And it really saddens me because what it's going to do is leave owners holding the bag. So what this says is, and it sounds really benign when you read it out loud, but I'll tell you what in effect it creates. You have to have actual physical damage to get any kind of compensation. You have to have an actual failure to get any compensation or a verifiable danger. So I have a case right now with a condominium complex on the east side where the engineer has said, okay, this stucco is failing in this building, and these other 3 buildings have the exact same defect, that the elastomeric coating was not put on correctly, and they're going to fail, but they're not currently failing because they were like 2 years younger than this other phase. But we know that they were constructed defectively because we can tell from forensic testing. Well, that means that unless and until those other buildings fail, they can't get any compensation. And if the statute of limitations runs out before those buildings actually fail and start leaking and have major problems, then you're just out of luck. So what this is, I mean, this is millions of dollars we're talking about. So in this situation, my client on the east side is fine because they had this lawsuit before this law passed. But if this had happened in 5 years, their owners would have been stuck with probably a $2 million bill among like 68 owners, meaning literally some of them would have had to sell because you have to get a loan. So this is a big deal. When you have an engineer telling you this is a known defect and this is going to cause damage, it's just a matter of when. You can't get any kind of compensation for that anymore. It's going to be a real game changer. The builder's lobby is very strong, as you can imagine.
And this applies to any.
It applies to any, but it will, as a practical matter, have the greatest effect on condominiums. Yeah. So here's just a quick summary. These are action items. This is your HOA setting. You know, your fines, a new fining rule prior to January 1st. Liens. This is not. This is just something the board needs to be aware of. This is just really something that Goodwin will need to be doing for you, is sending that courtesy notice before the certified mail notice so that a lien can be filed for amounts that come due after September 1st. And just a note, and this is really for your HOA attorney and Goodwin's internal practices, but if you've got an amount that comes due after September 1st, if you haven't sent that courtesy notice, you can file a lien, and the good through date is simply going to be, August 30th. And that's fine, because the lien is going to say, okay, the amount due as of August 30th was X, and the lien continues to accrue for any amounts coming due after that time. So it's just something that we're going to, while this transition period is happening, we're just going to have to keep in mind, okay, we need to bifurcate these lien amounts if we haven't sent 2 notices. Yeah. Not a huge deal. So the architectural candidate solicitations for HOAs with more than 40 lots, so those board members can serve on the ACC. And then the new front yard fencing, adopt a rule for like disallowing front yard fencing if you want to disallow it and your documents don't already have that, and that's needs to happen before September 1st.
Cool, awesome.
And for condos, the new management certificates, filing with the county and TREC, and then the new websites. If you have more than 60 units, your documents have to be on a website. And as a practical matter, you'll just file with the county and TREC at the same time. But technically speaking, if you have a management certificate already of record, which all of you do, because Goodwin makes sure of that, you have a little more time to file with TREC. But we'll just get it done at the same time.
Mm-hmm. One thing to note, Connie, I'll send out a recap to everybody who registered for the call, and included in that is just a really practical guide of summary of everything that you can share with your board at the next board meeting. And there's also a package that Connie put together for help with getting all of these things done, whether you're an HOA or condo and need help moving the ball forward on being compliant with these new laws. You can work with Connie, and Connie will help you out and get that stuff going. So really helpful there.
Thank you. So now we're just going to run through quickly some of the near misses, some of the bills that were filed that through lobbying efforts and grassroots efforts from people like you that called in and helped us at the Capitol, we were able to, not just us, but our efforts helped in getting these bills not passed, the died in committee or what have you. A lot of them, I mean, we saw, I think, 6 chicken bills this session. Every representative's spouse seems to want chickens in their backyards, it seems. But if you want to go to the next slide, these chicken bills had a general theme. They would have allowed growing fruits and vegetables anywhere, front yard, backyard. You know, your neighbors could have a corn row and, you know, maize field in their front yard. Keeping 6 or fewer chickens, which if anybody's lived next to chickens, they're really cute and their eggs are great. If you don't take care of their pens, they're nasty. They attract rodents, they attract snakes, and they tend to get out. And anyway, it's not a one size fits all. And some of the most heated debates I've seen is over passing amendments to chicken rules in communities. It's just very personal to a community. And then rabbits as well. The legislation would have let you keep 6 rabbits. And the legislation also would have allowed for cottage food production operations in each home or condo. And I remember talking to one of the staffers on the phone whose office was pushing this bill. And I said, what is your concern with people having a little cottage food operation? You know, they're just making jam in their kitchen. And I said, well, here's my world. I'm going to have drug dealers with people coming and going all day telling me they're a cottage food operation. And I can't prove that they're not. It's a lot easier for me to say no businesses are allowed at all, because that's, people are going to abuse it. And they said, oh, I never thought of that. I'm like, yeah, welcome to my world. But also the cottage food operation, the way it's defined in the statute, it is a major operation. It is $100,000 or less in gross revenues. It's not just, you know, Aunt Betty making jam in the kitchen. So that is of concern, because that would potentially generate traffic in communities. So what was unsettling is just the amount of support for these bills, and not to be pejorative, but just kind of blind support. Like there's no middle ground. Like, you know, maybe owners have the right to put this to a vote, yay. But they just wanted, this was a one size fits all that would have been really problematic. You know, look at, you know, you have a 10 by 10 townhome in your backyard. I mean, sorry, your backyard is 10 by 10 in your townhome, and people gets to keep 6 chickens and 6 rabbits back there. That's not tenable or sensible.
No, and something I'm sure we'll run into again.
We'll see it again.
No doubt.
And so this was a bill, and it sounds good in theory, right? That your HOAs and condos have to give notice to everyone of covenant amendments published in a local newspaper. This sounds like a newspaper full employment act to me, because that is really expensive and nobody reads that area of the newspaper. Or mailed certified mail to all owners. I mean, Goodwin represents communities with thousands of owners. That is an ungodly amount of money, when all these documents have to be already posted on your website and adopted at a noticed meeting. And you know from the notice that an amendment is going to be on the agenda. And so this bill didn't end up getting anywhere. And I also talked to the author, and it turns out that this is not at all what he was getting at. He was trying to help a constituent that had deed restrictions without an association. And so it turned out to be a great big misunderstanding, and the legislative drafting service just didn't understand what he was wanting. So we helped him draft something that he would have actually helped him, but that didn't end up passing, which is kind of beside the point. But this would have been really problematic and expensive for associations. But yay, didn't pass. More near misses, voting. This was really bizarre. Why are we removing rights to vote by absentee ballots? Why are we making moms and dads miss soccer games to come to a vote so they don't have to assign their proxy? Anyway, it didn't pass, and it was a very strange bill. But that is something that our organization really supports, is absentee voting, so you can have direct participation without having to take time off from your schedule to show up at an HOA meeting if you don't care to. This is the scariest one yet in terms of board member liability, the chilling effect on volunteers. We would be scraping and begging, and probably would have had to amend bylaws to pay people to be on the board. And I'm not kidding. So what this bill said, which didn't pass, was that owners with 20% of the voting interest can call a meeting to remove a director. That's fairly common. That's not really remarkable. That's state law. That's in most of your bylaws. But it created a cause of action against directors. Owners were basically welcomed and encouraged to bring causes of action against HOAs in justice court. Any perceived violation of HOA statutes by a board member, any perceived violation of the governing documents by a board member, you could have a cause of action in JP court. JP courts are great for what they're good for. They're very informal. The rules of evidence don't apply. Justice court judges are often not attorneys, but you can be talking about as much as $20,000. And with the next slide, what was even more concerning is that under this as-filed legislation, the justice courts could order a director removed. That's unprecedented. Justice courts don't have what's called injunctive power. They have the power to say, okay, Connie, you owe Mitch $100, but they don't have the power to say, okay, Connie, you have to remove your guest house because Mitch doesn't like it. That's completely different. And so, but the justice courts were given injunctive power under this bill, and you could have been awarded a judgment by the JP for damages of up to $20,000 and a judgment of allowing the owner to deduct up to $20,000 from future assessments, which is really a problem. And there's a cause of action for violations of the statutes right now in county court, in district court, and it's not like owners don't have any remedy, and you have hearing rights. If you get, a violation, you have statutory hearing rights. This kind of thing scared me the most probably of anything. Well, maybe there's one more thing later that would chill or kill volunteerism. You don't sign up for being dragged into JP court. You don't sign up for having assessments increase 1 or 2-fold because it's so easy to sue your association. Well, I'm just going to do it because you don't have to be a lawyer to file a claim in justice court, and insurance rates would have been driven up, assessments would have been driven up. This was really a problem that I hope we don't see next session, but we're certainly prepared to fight it next session because we live and die by our volunteers, and we need nothing that is going to chill volunteerism.
Hard enough to find them.
It is hard enough to find them. This was a bill that, again, sounds good in theory, but wow, it would require HOAs to have audits every single year. I mean, I represent, and I'm sure Mitch does, HOAs with 2 units and 6,000 units. And they would have had to have the same audit each year. And audits are $5,000 to $10,000. It was unclear language. The audit has to be performed by a CPA if the owners vote to have it performed by a CPA. Well, in CPA land, there's no such thing as an audit that's not performed by a CPA. So what does an audit not performed by a CPA actually mean? It really, at the end of the day, my organization got with the trade association for CPAs, and their comment, which we shared, was there are literally not enough CPAs in Texas to do all of these audits because there are probably 40,000 homeowner associations at least in Texas. And anyway, it didn't end up passing. We ended up with the CPAs drafting alternate language that would have let owners vote to have an audit. So even if the board didn't want an audit, owners could vote to have an audit, which we thought was a good compromise. But nothing ended up happening with the bill, which is good because nothing is better than having a $5,000 cost every year, no matter what the size of your HOA. And next, this was the other one that was really high on my radar for potential unintended consequences. This was a bill, when we talked to Representative Colcourt's office, the intent of this bill was to say, okay, association, if you allow the Girl Scouts to rent your clubhouse, you can't disallow a politician. An owner wants to invite a local politician to speak at the clubhouse or have a fundraiser at the clubhouse. Basically, you can't let someone else use the clubhouse, but say no to politicians. Some associations don't like having political gatherings because they tend to be a little bit divisive potentially. And so some of them said, you can do anything as far as renting the clubhouse, but no political gatherings. So her intent was, for her staffer, just treat us the same as everybody else. And so what I told the staffer was, well, in your as-filed bill, you go way, way beyond that. And luckily this bill ended up not being pursued because perhaps she recognized that this was a lot more than she intended. But this would have, as filed, said you can have no restrictions on politicians for using common areas. So I told the staffer, so that means that if somebody wants to have 100 people at the pool for Representative so-and-so to talk every day, 365 days a year, they get to do that and we can't stop it. And the toddlers aren't going to get to use the splash pad and we're not going to get to recoup any costs. And I said, no, that's not our intent. And I said, well, that would be the effect of the bill. And then what the bill also said was HOAs cannot have any restrictions that curtail their owners' speech. Well, the First Amendment, right of free speech, does not apply to private entities. It says that the government can't prohibit you from standing on the Capitol steps and saying almost whatever you want. But you curtail First Amendment rights all the time by private contract. HOA restrictions are a classic example of that. You can't have a sign greater than this. You can't, paint your roof the color of the Confederate flag. That is a restriction on speech. And so her bill said associations can't restrict speech in any way. It's one thing to let owners, say whatever they want at an annual association meeting, which I hope kids don't come to these meetings if they get to say whatever they want. But what was really going to be the most potentially problematic effect was just the signage. Because that flag that you see on the roof, that is free speech. Ugly signs pointed at other neighbors, that is free speech.
It's a great picture, by the way.
Yeah.
I don't know where you found that. But.
I was just ugly HOA signs, basically. You can pull them up. But I mean, when people were bored during COVID, you get this. I had a couple of instances where people would paint the outside of their privacy fences with murals, which, in downtown Austin, they would have been lovely. And some of the murals were political in nature, and no matter what side of that fence you're on, but that's not what you sign up for, to come through your neighborhood and see a 10 by 20 mural of a political cause that is not necessarily your chosen cause. And it would have really created aesthetic considerations in communities, as well as created acrimony among neighbors. I don't like your mural. Well, live with it. I don't care if it's Save the Whales or something super controversial. What I say is that HOAs can't be the arbiter of causes. We just can't be. And we have to have the ability to control signage. And so luckily this didn't pass. She didn't really pursue it, but it's one of those things that sounds so good in a sound bite, and it would just have a lot of really problematic consequences in reality. So this didn't pass, but there was a big push this session from from billionaires. Frankly, it was Elon Musk, business partners got together, a lobby dream team, because they're pushing for density in the name of affordable housing. We see this in Austin a lot, right? We never met density that our city council didn't like. But this bill would have said that municipalities can't impose any height restrictions. So we all would have become Houston. Not that there's anything wrong with Houston, but Houston has intricate deed restrictions in neighborhood communities that we don't have. A lot of our deed restrictions don't impose height restrictions because developers know that that's left to the city. But if the city height restrictions went away, we would end up looking potentially like this photo, which I think is Houston, is your beautiful ranch story house in Pflugerville would have had a 6-story mixed use development next to it, which would be really not what I signed up for, at least when I bought my house. So anyway, it didn't pass, but we're probably going to see that next session. This another thing sounds really good in theory. We should all have a constitutional right of access. This was a constitutional amendment. You have to pass a House Joint Resolution in order to get a constitutional amendment put before the voters. And so this said that HOAs could not prohibit an owner's right to secure access to food, water, electric power, and shelter. So, okay, so we get to breed cattle in our backyards, and we get to drill wells and erect cisterns and build a power plant. I mean, really, it was just sweeping, well intended, I'm sure, but it would have overridden any, commercial use provision. If everybody's going to behave rationally, maybe it would be fine, but we know, and we have jobs because people don't always behave rationally. And, we would have seen, cattle farms and chicken farms and wells drilled in the backyard and all that good stuff.
Yeah.
So that bill had a lot of opposition because a lot of people understood all the ramifications of it. So it didn't go anywhere very quickly, and it ended up dying. Short-term rentals. This was a bill that would have prohibited cities and counties from banning short-term rentals and regulating the duration. And HOAs can impose their own short-term rental rules, but what I tell my clients is if the city will do the dirty work for you, let them, because it is a bear and expensive to enforce your leasing restrictions. And a lot of times it's really nice to rely on the city. You don't have a city permit, the city goes after you. It would have meant a lot of the burden would fall to HOAs rather than having the cities as the first line of defense against rogue short-term rentals. But it didn't pass, thankfully, from my perspective. But we can see that back. I think realtors want this. Of course, the RBOs of the world want this.
It's definitely not going away. They've got deeper pockets.
Yep.
Yeah.
And that's it. Happy to answer questions in the chat. And like Mitch said, he'll make these materials available. But I really commend y'all. And really my favorite part of my job is getting to meet, I call you the doers, the people that step up and take a hard job for your community and get not always a lot of love and warm fuzzies, but it's so important. And I really commend you for being active and educating yourself this way. So kudos to y'all.
Yeah, appreciate it. We'll be around to take some questions or comments. And again, we'll send out the recap of this, Connie's legislative package, and also her contact information should you need help with any of the next steps required from this process. So thank you, Connie, for your time today.
Thank you. Thanks for having me.
All right. And we'll have this get this in a format where you can share the recording as well and go from there. Look forward to connecting with you all if you have any questions, and appreciate your time today. Thank you for all your help.
Thank you.
Let's see.
I don't think there really any questions just about the Dallas STRs.
Yeah. No, pretty straightforward.
Yeah.
All right. Thanks, Connie.
My pleasure. Bye-bye.